Hey folks, James Abrinio here coming to you from Abrinio Law's podcast. Today I've got a pretty cool guest, a good friend of mine, Lee Livingston. So Lee, thank you for joining us here today.
Thanks for having me, James. I look forward to it.
Yeah, and just to give people a little bit of background, I've been trying to get Lee on for several months. I know him. We worked on a pretty big, really tragic case a few years ago. And since then, we've just stayed in touch and worked together, taught together. A little bit about his background. He's out of Charlottesville. He just started his own law firm, Livingston Law Group. You guys have been in business for how many years now? About 3 years, is it?
2 years. Yeah, we'll be
2 years.
Three in July.
Yeah, but certainly he's not new to the business. He's been practicing about 3 decades. Countless of those awards you see, Lawyers of the Year awards, U.S. News, Best Lawyers, all that jazz. A bunch of 7-figure verdicts. It's kind of a regular on his watch. He teaches at UVA Law, has done that for a while. He serves on countless CLEs, which is where lawyers teach other lawyers. So a big distinction there, on multiple boards, including the VTLA, Virginia Trial Lawyers Association. He even helps write jury instructions. I mean, the guy does everything. I would consider him a mentor of mine as well as a good friend, and he's just a good dude. So again, Lee, I really appreciate you coming on today.
Well, James, it's so good to be with you. As you know, any kind of mentoring relationship is a two-way street, and I've learned a lot from you, my friend.
Yeah, what not to do and how to teach lawyers not to make a fool of themselves. So I appreciate it. The reason I wanted you to hear today, in addition to just generally talking about medical malpractice, is there's some controversy going out your way in Charlottesville with the UVA Medical Center. Tell us what's going on there. What's going on in the news?
Well, there is a very unusual thing happening down here, James. A group of healthcare providers, faculty members, perhaps some non-faculty members. It's not clear who everyone is who's made this complaint or made this an issue, because they've remained anonymous. But a fairly significant number of people have voiced concerns about the leadership at the medical school, and they have gone public that they have concerns.
And what's interesting, because I Googled the letter, I was able to find it, and I'll probably link it to the show notes here. But I do think it's interesting that most of them have been anonymous. But can you tell us specifics? What are they alleging in this letter, and why is it concerning, especially you being a medical malpractitioner?
Well, there are general allegations that folks have done some things that they shouldn't be doing, that some of what they've done has not been helpful to patient care. So they are concerned about the leadership style and a culture that has developed, according to these writers of the letter, and that's their concern. They're not very specific, and that's been one of the retorts, one of the responses by the president of the university, to say, hey, they haven't been very specific, so how can we address this? In response to that, they sent a second notice, if you will, a shot across the bow, to say, look, here are all the meetings at which we've discussed these things. So there are specifics, there are some meat on the bones, they say, but they haven't, for very understandable reasons, been super specific about who, what, where, when, and how, and why.
Do you know whether or not, because my understanding is UVA leadership has said, it's not specific, so there's not the concerns aren't as valid as articulated. Do you know if they're taking any affirmative action, regardless of whether or not they think it's valid, to address any concerns that the public may have?
Yes, they hired an international law firm, Williams and Connolly, to do an independent review. So they will come in and do an investigation, and then that will generate a report. And that report will not be made public, but it'll be made to the university president and presumably the board that governs the university. And then they will have an independent review they can go by to address whatever concerns they think may be well-founded.
Okay. Now, what I'd like to do is talk a little bit about this in the context of just medical malpractice in general. You've brought me in on a couple cases, and so I've kind of getting a better sense of it. But For those folks that either they have a concern that maybe somebody in their family was treated negligently at the hospital or by a doctor, or they just want to learn more about medical malpractice in general, like what are some of the things that the public should be thinking about if they're concerned about how somebody was treated in their world?
Well, if you have a concern about treatment,
Mhm.
it's helpful to get advice from a lawyer who practices in this area. Uh,
Mhm.
I can tell you some of what to look for. And, unfortunately, there are a lot of mistakes in healthcare.
Mhm.
I was helping work with my dad at the hospital here recently, and someone didn't notice the timing of an x-ray, and it made a
Mhm.
difference. So it's always helpful to have someone with you, because the best thing to do is avoid a malpractice case to begin with. Obviously,
Mhm.
you'd much rather have your health than a big claim of any kind. So having someone with you who can help look over their shoulders, who can help look at the records, with my chart and other kinds of portals, you can now follow your medical records and so forth. So the prevention is the most important thing. But if you find yourself thinking, gosh, we may have a case, then there are a number of things you can look for.
Well, let's talk about that. Let's say somebody thinks, you know what, I think we have a case. Let me call Lee, and I want to see what he thinks about it. What are some of the structural things about medical malpractice claims here in Virginia that may make a claim more difficult? And what are some of the things you think they should be considering as they're reaching out to call you or considering calling you?
Sure. One of the biggest things is the nature of the harm. If it's
Mhm.
catastrophic or near catastrophic injury, it certainly merits looking into if it has some of the other things we'll talk about. But if you make a good recovery, if you're talking about just a temporary, say an overnight extra stay in the hospital, or very limited amount of medical bills from any mistake that was made, or maybe it's just the shock and fright of it, most of the time, and again, this is an overgeneralization, but most of the time you can't get those out of the gate because these cases are very expensive to prosecute. You have to hire an expert in the same field as the potential defendant. It takes a doc to sue a doc, and you have to have them sign a confidential paper that says, hey, I think there was malpractice here, before you can even serve a lawsuit on a healthcare provider. So those are some of the things, James, to have a very serious injury and to have something that no reasonable healthcare provider should be doing. It can't just be a mistake where you recover or there's really no real harm. The old adage from our common parlance, no harm, no foul, is true in medical malpractice as well.
What about the patient or the potential client that calls you up and says, look, my treating doctor said that this doctor really messed up, and we're ready, and I've got a slam dunk for you. Um, and they're right down the road. They're in Virginia, they're in Stafford or wherever. Talk about some things that you'll want to consider when talking to that client.
Yeah, that's a good question. That's certainly one of the things. And by the way, I'll do seminars to help other lawyers weed
Mhm.
out good malpractice cases and when to call me, because, as you know, most of my cases come from lawyers like you.
Mhm.
One of the factors is, has anyone criticized the potential defendant doctor? And
Mhm.
if a treating doctor has raised an alarm, that can be important. Many times we find that there's criticism, but it wouldn't rise to that bar of malpractice. So sometimes they don't like how things were handled, but they don't say that it's a breach of the so-called standard of care. And what is the standard of care? Well, it's what doctors say it is. So if they're qualified and they're in the same or related field of medicine for the defendant, they can come into court and say, I think this fell below the standard, or I think this exceeded the standard or met it. And that's what jurors are supposed to listen to. And that's what they typically will follow. It's the so-called battle of the experts. So in your example, you have a treating doctor who has said, hey, this wasn't right. Well, is that physician in the same field of specialty? You don't want to have a neurologist criticizing an ER doctor necessarily, but you can think about that. And then don't be shy. Say, do you think I should contact a lawyer? Do you think this is a case of malpractice? And many times that doctor will say, whoa, that's not what I'm saying, and then sometimes when they say that, they're absolutely right, and it's not a deviation from standard of care. Other times it's just, wait, now I don't really want to be involved. So you have to use your spidey sense to try to get a feel if you're talking about relying on a treating doctor. I can tell you that in my 30 years of doing this, I may have had maybe half a dozen treating doctors either sort of turn in the defendant or step up to the plate and testify against the defendant on the actual standard of care. Many times treating doctors are covering other issues like what happened as a result of what this doctor did, but they're not squarely in that world of saying, I think that was a breach of the standard of care negligence. We also have to prove, that the foul caused harm, as we said before, and that's the causation element.
Do you find in most of the cases I've been involved in, we've had to go out of state to get doctors. Do you find it a valid concern that, Dr. John doesn't want to testify against Dr. Smith because they know each other or they're right down the road from each other? Do you think that plays into it?
Oh, certainly it does. It plays into it for doctors just like it does for lawyers. I mean, I do legal malpractice as well when when lawyers mess up. And, if you know that person, you're not going to want to get involved in a case. There's nothing that obligates you to step into the courtroom arena and criticize a colleague. And so it's more likely that you'll find doctors out of state, but not always. I have some doctors in Virginia that will testify because they don't know the other doctors. They're not super close to them. They're not going to rub shoulders to them at meetings necessarily. They might see them there, but they're not going to be, breaking a relationship. And it depends on the field of specialty, right? So there aren't that many neurosurgeons. There are a lot of ER doctors. So you're more likely to find an ER doctor in state, but you might have to go out of state. It all depends on the specifics of the case and the people. Sometimes you have a very well published defendant who is well known to providers, and they're like, oh, well, I don't think I want to go up against her. But then on the other hand, you'll find somebody out of state. I just recently settled a case where I had to go to great lengths to find a doctor who did a very specialized procedure. And it took quite a bit of cajoling to get this expert on board. But once he did, it really helped the case tremendously.
I've heard, and I think I've experienced that defendant doctors are reluctant to settle. And we hear about, in our world, we hear about this data bank. Explain what this data bank is as far as settling cases and why doctors are thinking about it. Or database, sorry.
Yeah. The lawyers who represent doctors have more familiarity with this than I do, but I can say that they don't want to go into the data bank. They would rather avoid a reportable event. These are records that credentialing authorities keep. They're not open to the public. And so my understanding is that if they get a certain number, it might be like 3 within 10 years, but don't hold me to that, that the Board of Medicine might investigate them or take a closer look at what's going on. So that's one aspect of it. But not always. The data bank might play into it. Most of the time, I think it's the doctors either really believing in their care and sometimes believing in it, but then having to be persuaded by their lawyers and their own experts that, hey, maybe you missed one here and you just don't see it. But other times they actually come to the table and the doctors will say, look, I messed up. Please, that's why I have insurance. Please get this resolved. And I think doctors have been behind some of the settlements that we see as well.
Okay, great. That's good to hear. Another unique thing, you mentioned in medical malpractice cases, you have to get a doctor to certify before you can serve it. That's unique in civil lawsuits in Virginia. But another thing is the medical malpractice cap. What is that, and what should potential clients and patients be thinking about that?
Virginia is really in the dark ages on this. We have a draconian cap, which means if you have a horrible malpractice committed on you and you are in a wheelchair for the rest of your life, and we can put together what's called a life care plan where, say, you need 24/7 nursing care around the
Mhm.
clock because you can't feed yourself, but your mind is fully there. You're not ready to go, but you're paralyzed. If that's going to cost $8-10 million for the rest of your life, you're not going to get that in Virginia like you would in other states. The
Mhm.
maximum you can get if the malpractice happened today, I believe, is 2.6 million or maybe 2.65. It's going up $50,000 every July until it gets to 3 million.
Mhm.
And it might be one slight modification to get it to 3 million in that last year. But in other states, they have, many states, not all, but some states have caps on pain and suffering, meaning your emotional distress and so forth. But Virginia's applies to all economic damages as well. It's a hard cap, as we say. So insurance companies know that that's the most they can ever lose. So they always work you against the cap to try to resolve cases. So it's very unfair to those who are hurt the most. And what's even more tragic, James, is that it then leads to the state, essentially taxpayers, supporting these people who are victims. So the person who may have committed the malpractice, the negligent act, gets off to some degree, but then we taxpayers support people who can't afford the care that they have to have just to go on living.
Interesting. I hear often, as I'm sure you do, that we need tort reform. We hear doctors complaining about insurance premiums and frivolous lawsuits. And this is more of a broad question, but what's your response to that? Do we need tort reform? How important is a medical malpractice, at least on the plaintiff side, the ability to sue for injuries important, do you think, in our system? And do you have any kind of broad things that you would fix about it if you could?
Well, thank you for that very narrow, precise question, James. And spend a couple of hours talking about that. I'll say, well, which
Yeah.
side do you want me to answer, counselor? I'm going to object. It's a compound question. Uh, let
Yeah.
me let me take basically what I think the gist of it is. You know, in Virginia, is this justified? And it's absolutely not. It's just not
Mhm.
because all the studies that were done and that I've seen show that the rates haven't changed much for Virginia doctors. And are there isolated parts of the United States where maybe they needed some tort reform? Maybe, but I haven't really looked at those. In Virginia, if you're going to do tort reform, don't do anything like this, right? Make the people who are the most injured and the most hurt subject to the worst penalties,
Mhm.
and take their remedies away. What benefit is that? That's
Mhm.
really upside down. But as far as insurance, my understanding from the research that's been done by the Virginia Trial Lawyers Association and others. And back when I was president, luckily we didn't have a big tort reform push, and it's been years since there really has been because I think Virginia legislators have largely seen through it for many decades now. But
Mhm.
the fact of the matter was that insurance companies were making the most profits on
Mhm.
professional liability insurance. Lawyers and doctors, they make a lot of money
Mhm.
selling you policies that everyone has to have, or at least for doctors, they pretty much all have the coverage. So they'll pay whatever you're going to charge. And were the payouts justifying those high rates? Arguably not. But I'm not an expert on the insurance industry, and I can only speak to you from my biased camp in favor of the victims of injury and of malpractice.
Well, Lee, is there anything else that you wanted to share that you think would be useful, just generally, for somebody that is concerned about how a loved one was treated, and maybe they're thinking about calling a medical malpractice attorney like you, that you think they need to think about?
Well, it's many people don't report malpractice. There was one
Mhm.
study that suggested up to 90% just it's let go. Now,
Mhm.
many of those claims might not be economically viable, but for those people who do have a serious injury or a family member has a very serious injury, I would say don't let the courtesy and kindness of the healthcare providers trump a serious investigation because there's actually an I'm sorry law in effect, so that doctors can say, hey, I'm really sorry this happened to you. And that can't be used against them. So there are protections for doctors like we don't see in other fields. And I would say don't be shy about asking hard questions of people you like, people who are intending to do good. No one's intending to harm you. If they are, that's a criminal case. You do those, James. I don't do any of that. If there's ever intentional harm, definitely call James. But here, we're looking at just don't be bashful, take someone with you, be an advocate for yourself, do your own research if you can, and don't be shy about consulting with a lawyer. They're all free. We don't charge for these evaluations, and they'll tell you if they're able to look into it. The system works really well because it works on contingency. And so your lawyer's interest is aligned with yours. If they think it's economically viable and they can get some relief for you, they get some pay for themselves. And if they can't, or they don't think so, they're likely to tell you no. So I think it's a fairly good system, but take advantage of it if you think you should. But be aware that if it's not a serious injury, it's unlikely someone's going to give it a serious go.
And that was actually my last question, but before I close up shop, contingency fee, tell us just from a 1,000-foot view, what is that so folks can understand what that means?
Oh, sure. The lawyers don't get paid by the hour like in most kinds of work that lawyers do. They get paid a percentage of what they recover for you. So the standard rate for most car wreck, truck cases, things like that, 33 1/3%, 1/3. The standard for professional liability, legal malpractice, medical malpractice, about 40%. Takes generally somebody with more expertise and networks of experts and connections that they can make to put forth a professional liability case. So that's why the rate's a little different. But if there's no recovery, you don't have to pay the lawyers anything. Now, costs are a different matter, and as far as out-of-pocket costs to pay the experts and things like that, you have to talk to your lawyer about how that works. But generally, it provides everyday people with potentially very good lawyers who could be, working for Fortune 100, Fortune 500 companies that would pay them, huge amounts of money to litigate for them. It provides access to justice for those who can't afford to pay a lawyer.
Well, look, Lee, I appreciate you again taking the time to speak with me. Anybody watching this video, again, Lee is a good friend of mine, but most importantly, even though he's a good guy, he's a great lawyer, got a great reputation, and a true advocate for his clients, and somebody from like me that's still learning and has a handful of people I look up to in the legal profession. Lee, you're one of them. I really appreciate it. And so make sure to reach out to him. If you have any questions, his information, I'll put him in the show notes. And obviously you can reach out to me and I'll get a hold of him as well. But again, Lee, I appreciate it. And keep working hard, okay?
Thank you, James. You're a star. I appreciate being a part of your program here.
Yeah.